Real property, mortgages. The rights of real estate lenders and borrowers. The borrower in a mortgage is known, surprisingly, as the mortgagor, while the lender is the mortgagee. In exchange for a note memorializing a promise to pay and a security interest acting as a right to foreclose, the lender provides the borrower with funds to purchase the real estate. There are two components to the transaction: the note forming the promise to pay, and the mortgage or security interest forming the right to foreclose. In California and some other states, a third-party trustee holds the security interest in a deed of trust. When a borrower, mortgagor, defaults on the note repayments, the lender, mortgagee, has two options. It can sue on the note to win a personal judgment against the borrower, or it can foreclose and force the sale of the real estate to satisfy the debt. Foreclosure is obviously the most popular option with lenders, as the real estate is usually the most liquid form of asset held by the borrower. Under the common law, up to the date of the foreclosure sale, the borrower, mortgagor, has a right to repay the debt and prevent the foreclosure. This right is known as the equity of redemption and cannot be contracted away. The law will not allow the lender to eliminate the borrower's right to redeem up to the day of the foreclosure sale. Many states have protected their homeowners with additional statutory rights that allow them a window of time, perhaps 6 months, a year, sometimes up to 3 years, to buy back the property from the buyer at the same price paid by the buyer at the foreclosure sale, plus associated expenses. So in states with this statutory right of redemption, a buyer of real estate at foreclosure sale must be prepared to sell the property back to the borrower, the mortgagor, at the same price paid at the auction. When the lender, mortgagee, decides to foreclose, it has to provide notice to the borrower. This is usually 30 days. The lender accelerates the debt payment so that it can recover the full loan plus interest, not just the borrower's missed payments. The lender usually goes to the court for a court-ordered judicial foreclosure, whereby the auction is held on the courthouse steps by the sheriff, who sells to the highest bidder. The proceeds of the auction go first to the lender to satisfy the debt. If there's a surplus after the debt has been repaid and the costs of the foreclosure auction have been deducted, this then goes to the borrower. If the proceeds are insufficient to satisfy the debt, then the lender asks the court for a personal sufficiency judgment against the borrower, to use the borrower's personal property to pay the balance. The alternative to a judicial foreclosure by the courts is a private auction known as a power of sale foreclosure. This is permitted only when agreed by the parties and must take place in a public place. Most states allow the mortgagor, the borrower, to bring suit to cancel the sale only where the bid price is so grossly inadequate as to shock the conscience, or if fraudulent or unconscionable conduct has occurred. Although not technically a mortgage, a deed of trusts acts virtually identically to a mortgage and has an important advantage for the lender. The deed of trust is held by the trustee, who is able to foreclose without going to court. Foreclosure is made quicker and somewhat easier with a deed of trust. An installment contract is not a mortgage, as the buyer does not borrow funds from a lender to purchase the property, but agrees to pay the seller directly through a series of installment payments. If the buyer fails to pay, the seller can go to court to ask for a judicial foreclosure. The seller also has a right to forfeiture. The monies paid by the buyer are effectively treated as rent and kept by the seller. the buyer is ejected and title to the property is also retained by the seller. This can have harsh results if the buyer has made a number of installment payments and has almost completed the purchase. The courts will approve the seller's right to forfeiture unless it would be so unfair to the buyer as to shock the conscience of the court. To prevent predatory behavior by buyers, in certain situations, a court will treat a deed of sale as a mortgage. The court views the deed as a disguised mortgage. The situation involves a sale of real estate by an owner in financial distress, where the seller fails to vacate the property following the sale, continues to pay taxes and other costs paid by a real estate owner, and the price paid by the buyer is far below fair market value. By interpreting the deed of sale as a disguised mortgage, the court provides the seller with a right of redemption. The seller is able to redeem the mortgage, or the purported mortgage, by repaying the buyer, and this allows the seller to take back title to the property. The buyer is thereby unable to take the property at a bargain price by purchasing it from a desperate seller in such conditions. If the seller is able to raise the funds to repay, the courts will allow her to take back the property by treating the sale as a disguised mortgage. When there are multiple mortgages on a property, they are ranked in priority, usually according to the order in which the mortgages were made. A mortgagee lender has a right to redeem up and foreclose down. Redeem up means a new mortgage can eliminate the old mortgage by paying it off. Redemption. Foreclose down means that a mortgagee lender can initiate foreclosure, and the lower mortgagee lenders cannot prevent the foreclosure as long as they are parties to the foreclosure by service of process. The mortgagee lenders effectively form a line when it comes to distributing the proceeds of the foreclosure auction. The first lender is first in line and is paid in full before the remaining proceeds are then passed to the next in line. If there is insufficient funds to pay the last lender in line, the last lender in line gets only the right to sue the borrower for a personal judgment. Of course, the borrower mortgagor is always last in line and only receives the surplus after all the mortgagee lenders have been paid off in full. In many situations, the later lender is in a position of power. An agreement by a first lender to cede priority to a later lender will be binding and supported by the US courts. These arrangements that reorganize priorities of the mortgagee lenders are known as subordination agreements. The higher in priority agrees to subordinate his claim to a lender lower in priority. If the real estate buyer acquires the property with several loans, they all attach on the same date, the date of purchase. A prior judgment lien would also attach on the same date. In this situation, we need rules to establish priority. The rule is that the purchase money lenders get priority over judgment liens. The lenders providing funds for the purchase are first in line. If the seller provided some of the purchase money, he is ahead of the banks. Of course, the banks can request the seller to subordinate and usually force the seller to sign a subordination agreement before providing the funds for the conveyance. Upon sale of the property, the bank and purchase money lenders are paid in full before the judgment lien is satisfied. If a mortgagee lender is not made party to the foreclosure, perhaps because its claim was simply overlooked, its loan will not be redeemed from the proceeds of the foreclosure sale. In this situation, the mortgage remains as a secured claim on the property. The mortgagee lender retains rights to foreclose on the property, even though the real estate's been sold. The new buyer can lose the property through a second foreclosure initiated by this unjoined lender. As we've learned on previous slides, bidding at foreclosure sales carries some risks. The The statutory right of redemption in many states means that the new owner may be forced by the courts to sell the property back to the previous owner at the price paid at the foreclosure auction. The window of opportunity for the previous seller to raise the funds to buy the property back ranges, but in some states it can be as long as 3 years. The buyer can't make a profit on this transaction, but can recover some expenses. The foreclosure buyer also must be wary of prior mortgagee lenders. If the prior owner failed to join all the mortgagee lenders in the first foreclosure, the new buyer can pay for the property, then lose the property in a subsequent foreclosure sale, with proceeds going to settle the debts of the previous owner. The lender mortgagee's right to foreclose can be delayed if the borrower mortgagor declares bankruptcy. A bankruptcy petition, such as Chapter 11 or Chapter 13 reorganization, or a Chapter 7 liquidation, once it's filed, creates an immediate automatic stay. This operates as an injunction halting the foreclosure sale. Secured creditors, such as the mortgage or lender, must then petition the court and must show good cause for the sale to proceed. A locked-in, low interest rate can form the incentive for a buyer to take over the existing mortgage rather than seek a new mortgage. In some situations, the buyer can acquire the existing mortgage with the property. The lender's consent to transfer to the new owner is required if the mortgage contains a due on sale clause that forces the seller to pay off the mortgage upon sale of the property. These due on sale provisions are enforceable in mortgages as a result of a federal statute, so the lender can force the seller to pay off the mortgage when the property is sold. However, instead the lender may consent to have the mortgage transferred to the buyer. There are 2 methods of having the mortgage transferred to the buyer. The buyer assumes the mortgage or takes subject to the mortgage. When the buyer takes on the mortgage of the previous owner, under the assumption approach, the buyer promises to make payments on the loan. The lender still holds a security interest in the real estate and of course retains the right to foreclose on the loan if the buyer defaults. The buyer that assumed the mortgage with the consent of the lender is primarily liable. The seller, an original borrower, acts as a surety, a guarantor. Both the buyer assuming the loan and the seller are on the hook to the bank for payment of the mortgage. The lender is able to seek payment from both the buyer and the seller, for both the debt and the deficiency, should the foreclosure sale fail to pay off the total debt due. If instead of going after the buyer or foreclosing on the property, the lender seeks payment from the seller and the original borrower, the seller can be forced to pay back the bank. Now this would leave the buyer with the property free of the mortgage, and would not be a fair result from the perspective of the seller, as he's paid off the lender himself and the buyer holds the property free of the mortgage. So the seller has a right under the doctrine of subrogation to seek recovery from the buyer in a personal action. Subrogation gives the seller the rights of the creditor he's paid off, so the seller is able to foreclose on the mortgage to recover the funds he paid to the bank. The lender in this scenario recovers from the original borrower, the seller, and the original borrower then gets reimbursement from the buyer that assumed the mortgage. If the buyer does not assume the mortgage, there is no assumption agreement signed, but the buyer takes the property subject to the mortgage. The buyer is not personally liable for the mortgage, but is liable to the lender for foreclosure if the mortgage is not paid. The lender retains the right to foreclose on the property, but neither the lender nor the seller has right to bring a personal action against the buyer. The lender has a right to demand payment from the original seller, the borrower, the mortgagor. If the seller is forced to pay the lender, he can seek reimbursement by foreclosing on the property himself. Then under the doctrine of subrogation, the lender's right to foreclose passes to the seller when the seller pays the debt of the buyer. so the seller can then foreclose on the property. By taking subject to the mortgage, the buyer risks losing the property to foreclosure, but as he did not enter an assumption agreement, the seller does not assume any additional liabilities. The lender mortgagee can foreclose and can seek payment from the original borrower mortgagor, but neither is able to bring a personal action against the buyer. Mortgages are often sold from one bank to another. This is achieved by assigning the note. The security interest, mortgage, automatically tags along with the note. The body of law governing these transactions is Article 3 of the Uniform Commercial Code, which has been adopted by almost all the states and deals with all forms of negotiable instruments. The most common form of negotiable instrument is a check. It acts like money and is easily transferable when it's properly formed and endorsed. To qualify as a holder in due course and inherit all the rights under the note, the bank acquiring the mortgage must be a good faith purchaser for value, and the note assignment must be 1. Negotiable. It uses language allowing the transfer, such as to the order of. It must be endorsed, signed by the assignor lender. It must be delivered. The original note must be in the possession of the assignee. The requirement of the original note is intended to prevent the same mortgage being sold more than once by unscrupulous bankers. If this does happen, in a battle of the bankers over who owns the mortgage, this is settled by looking at who holds the original note. The bank that accepted a copy loses, and the bank that demanded the original wins. With an endorsed negotiable note delivered to a good faith purchaser in original form, mortgages are transferred from one bank to another. The new holder in due course gets the note and the right to foreclose, and consent is not required from the borrower mortgagor.